On behalf of our panel, we are excited that IIP included this. And why do I think this theme is important? And why is what Professor Khanna is going to say important? I think it's because a lot of what happens in economic development and growth, especially when you think about innovation or adaptation, happens at the intersection of law and economics, often not very visible, and often not acknowledged. And the story that you're going to hear today from Professor Khanna is a fascinating one. It's about innovation, it's about unexpected champions, it's about adaptation, it's about institutional change in a country where institutional change is often very difficult. Lastly, I think you will see that there are important takeaways, not just because of the scale and complexity of India's challenges and achievements, but there are takeaways for India and the US and also for other countries, which are grappling with the challenges of development, growth, and inclusion. So, Professor Khanna, without further ado, you have the floor. Thank you.
Thank you, and good morning. Thank you, Amit, for the very generous introduction, and thank you, Dr. Chibler, for inviting me, and to IIP for extending the invitation to join you today. I'm very much looking forward to your thoughts and suggestions. Also, I'd like to echo the sentiments of the earlier speakers to also extend our condolences and deepest sympathies to the victims of the terrorist attack of the other day. Today, I'm delighted to be able to present a paper I've worked on for some time on the development of India's home mortgage market and insights for law, institutions, and economic development. And as Amit mentioned, normally when one thinks about development and economics and law, there are many, many theories about how these three things interact with each other. Some people will stress the growth of institutions, some will suggest economic growth is significant, and others will suggest yet other factors are important. But most of the time, the discussion on economic growth and law moves often at the theoretical level. We don't usually get to look at actual instances of market development. So I became interested in hunting for examples of market development. And since I teach corporate law and white-collar crime, not how to do it, of course, but the law related to it, I wanted to look for something in the financial market space. And I thought the home mortgage market would be a nice ubiquitous example that most people intuitively understand, but for various reasons was largely non-existent in India. So what I'm hoping to do in my time with you today is to go over the study of, or to provide a study of the home mortgage market's development in India, looking at how do markets function, develop, and grow when you have weak law and enforcement. And I don't use this term pejoratively, just as a descriptive matter. There are very, very few studies actually in the literature on how do actual markets develop. So there wasn't too much of a template upon which to build, so pardon it if it sometimes seems like I go off meandering in a particular direction. What we're going to look at, hopefully, and hopefully the insights we'll be able to extract, will be how does development occur in this context? What does that tell us about the interactions between law, economics, and institutional development? And very importantly, the role of private players, often unappreciated private players. I'm a law professor, so of course, my natural inclination is to think that lawyers are somewhat underappreciated, but that may not be a commonly shared view. We'll talk a little bit about private ordering and, of course, economic development. I should mention at the outset as well that the paper as I wrote it here looks entirely different than what I had imagined it would be when I started the project, which is one of the reasons why I think research is fun, is that you start somewhere and you end up somewhere else. All right, so how did the home mortgage market develop in India? And the key problem we're going to identify is that for almost a century, it was very difficult to imagine the development of the home mortgage market in India because the key advantage of a mortgage, which is the ability to attach the collateral, the house, was actually very difficult to do in India. And that meant that the lengthy delays in enforcing mortgages and in sort of ensuring foreclosure on the property essentially meant that very few banks would be interested in entering the mortgage market because there was no real advantage to them. And indeed, one of the most puzzling things is, why did they then enter? after a century of doing almost nothing. And what I'm going to suggest to you is that lenders early on relied on dysfunctional aspects of India's criminal justice process to address dysfunctional aspects of its civil mortgage process, what I call in an earlier draft of the paper, two wrongs make a right. But as we'll discover, later in the same developmental time frame, we're going to have examples of the people who were benefiting from the use of the dysfunctional criminal process, realizing that they needed to move away from it because the system was beginning to cannibalize their own profits. And so they pushed for new legislation that somewhat indirectly actually achieved their goals of enhancing their ability to foreclose on property. That new legislation began having a greater impact quite quickly, and we quickly saw banks and others moving away from the criminal process towards a more refined, shall we say, civil justice process, although certainly not the one that most people might have recommended when they first started. And then hopefully we'll get a chance to talk about some of the implications of this analysis in this case study for looking at the incentives of the players in the market and how they developed and helped to grow the market. And also hopefully at a theoretical level, to maybe refine one's understanding of how development actually occurs. That is usually not a one-step process. It's a multi-step process that has many sort of intermediate steps, allowing time for people and those in the sort of sector to address the uncertainty that comes when you're changing from one set of equilibria to another. A point that is often, I think, underappreciated when people think about how does transition actually occur. There's a tremendous amount of uncertainty moving from one state of affairs to another. And that level of uncertainty tends to be much higher in emerging markets because you don't have as many examples of the bigger market structures. We'll talk about private ordering, a little bit on role of foreign players in investment as well. Okay, so what is the state of the Indian home mortgage market right now? Right now, it's basically the poster child for wonderful financial market development. We're seeing somewhere between 12 to 15% growth annually, 80% loan to value. That means if you have a $1 million home, you're able to borrow 80% of that. So you only need 20% down to actually buy the property. It's a 20-year mortgage. It bears many similarities to the American mortgage market. It's still relatively small to other countries. In 2012, it was 6% of GDP. The mortgage to GDP ratio was 6%, but now it's about 13%. But historically, this wasn't always the case, right? In 1993, that's just 31 years ago, India's mortgage to GDP ratio was basically a rounding error, 0.3%. To put that in sort of comparison, the US's mortgage to GDP ratio at that time was around 65%. This is just a gigantic difference, and that's true across Western Europe too in differing degrees. The terms you had for mortgages were absolutely terrible. 33% loan to value means that if you had a $1 million home, you had to have 67% of the money up front yourself. Then you would take a loan for 33% of it, and you would pay 17% per year, and you were required to pay back in 5 years. It doesn't take a great deal of school mathematics to understand that you're probably better off just waiting 5 years, saving enough money and just paying for it outright, which is what most people essentially did. So then what happened from 1993 to now that it's gone from 0.3% to 13% while India's GDP has been growing? That suggests there's actually been quite a lot of absolute value growth in the mortgage market. What changed? Pre-1993, we had a very poor market for the reason I primarily identified. It was very difficult to foreclose on property if the borrower did not actually pay for the mortgage. And that led to other sorts of affiliated problems. You had weak credit information. Employment patterns were not the same as they are now. And of course, housing structures and how people house themselves were different as well. Indeed, most of the funding pre-1993 came from state-owned banks, but they weren't really focused on the mortgage market per se. They were focused on building actual houses and things like that. The key actual growth phase was from 1993 to 2003, where the mortgage market in India increased by 1,000% or more. It went from 0.3% to 3.3% of mortgage to GDP ratio, while the GDP ratio was actually growing. So that 1,000 is actually a floor, not the ceiling. Then from 2003 to 2015, it doubles. And then from 15 to now, it's doubled again. So what we're seeing is really the key growth phase of this 1,000% growth. that's the one I'm going to actually focus on because I think that's the most interesting. And there are reasons why I'm ending at 2003 that hopefully will become apparent as we go through the discussion. Okay, so why did it not grow for so long? Now, a lot of people said, well, maybe they didn't have a mortgage law in India. That's not true. India's had a mortgage law since 1877. That is not a typo, 1877. But there was zero mortgage market for 120 years approximately. Why is that? Largely, it relates to Section 69 of the Transfer of Property Act. You need a court order to transfer property, but prior to 1993, land titles were very unclear. We had the deed system in India, which meant there was no central registry of property. People walked around with parchments, some of them tattered and falling apart. I remember once when I was in India looking at old trust documents, you could literally pull up the document and it would disintegrate in front of you, which was somewhat horrifying if you own that piece of property. Surveying of land and boundaries was awful, and people often describe their boundaries as the tree over there, which is not a terribly useful way to describe your boundaries. The ownership structure of property was often very difficult, partially because things weren't written down, but also because a lot of property is held in the Hindu undivided family structure. For those of you who are not into the sort of legal structure, that's just the joint family structure. And it's a very misunderstood concept, but it does mean it's actually complicated to figure out who owns it and who can actually pledge it to a bank. And there, of course, there were delays in litigation, which most people know about, and no prejudgment interest and fairly high court fees. Banks also faced great difficulty in assessing credit risk, partially because there wasn't a central registry of sort of identifying credit risks and credit scores, but also because the economy pre-1993, there were high taxes, and you typically found people taking steps to avoid paying those high taxes, which means keeping opaque structures. Opaque structures make it hard for people on the outside to actually assess credit risk because they don't know what they're looking at. And as a result, you really didn't have any kind of credit rating that made it more risky to enter this space. Employment patterns were a little different then than they are now. Many people were employed in the government, and often they provided housing or stipends. So it wasn't essential to actually need to push to get housing. That over time began to change. All right. And then, of course, we had people living largely in bigger sort of joint families than they do now. As a result, you really didn't have much of a home mortgage market at this time. And when banks lent out, they relied on negotiation and reputation and kind of strange personal guarantees to enforce these rules. As a result, entering the home mortgage market was unattractive to banks. And of course, that's why you have those terrible terms, 33% loan to market, 18% interest, and so forth. Okay. So why did it start growing in the 1990s? Well, there's a ton of macroeconomic factors that would suggest that would be greater demand for the housing sector. You start liberalizing the economy, and now you start seeing young professionals moving from some parts of the country into the big cities, increasing demand for housing. And that leads to a push to sort of grow the sector. Those younger people were also having more accounted for money. They were getting direct payments from their employers as opposed to family businesses. And often now, their ability to assess your sort of net worth was easier too, because you're getting official payments than you did before. Cities had better, not perfect, property titles compared to the rural areas. And so the properties that were likely to be the subject of mortgages were easier to actually assess and title. Other sorts of developments. The government allowed private banks in. You found people attempting to reform the debt collection system, trying to speed it up through something in a law in 1993 that basically failed, and so forth and so on. All of these together increase the demand and the potential value of having a home mortgage market, but they don't do anything for the problem of actually enforcing your mortgage, because the attempt to do that, the 1993 Act, failed. So then how did banks get comfortable entering the market? To assess that, I actually decided to interview the general counsels, that is a top legal officer, at all the banks in India that were involved in the mortgage market between 1993 and 2003. Now, you might think, my goodness, that seems like a Herculean effort. And I like to let people think it is, but it wasn't as Herculean. Since the market was so small, there were only 16 banks that were actually giving out mortgages. And I went and I approached all of them, and I got interviews with 15 of the general counsels, which I thought was quite remarkable. Indeed, the 16th one didn't have time for an interview because he had died before I got to him. And as a result, I became humbled by the influence that a small law professor truly has. I cannot reach beyond the realms of the material world and ask him to be an interview subject. The other 15 I did get a chance to speak with, and quite a bit of depth and multiple times. I also spoke with borrowers and other people affiliated with the market. Incredibly, they all said almost exactly the same thing, which was lenders, that is the banks, use Section 138 of the Negotiable Instruments Act of 1881. You might think, well, what is that? That is a regime that says bounce checks are a violation of the law. For the first 107 years of this law, it was a civil violation, which meant you would have to pay a penalty. You'd have to sort of pay a civil liability judgment. 1988 rolls around, and amendments were made to the Negotiable Instruments Act that made bouncing a check a crime, carrying a 1-year jail term. This amendment is not the result of any lobbying by the home mortgage industry, because there wasn't a home mortgage industry, so there was nothing to lobby with. It was a result of basically small shopkeepers getting very irritated that people would cut checks and they would bounce all the time. So the people in the business in 1993, this is just 5 years after the law was enacted, figured out a way to try to enforce their mortgage claims, which was the following. They said, let's start offering longer-term mortgages, right, with monthly payments. As an example, a 20-year mortgage with monthly payments means that you're looking at a stream of 240 checks to pay for your mortgage. They would have you sign post-dated checks on the first day that the mortgage was granted to you. So you sign the deal with the bank, and that very moment, they bring out 240 checks already post-dated with the amount set. You start signing. I didn't believe them initially because it sounded bizarre. So I asked the bank GCs, would you mind if I just sort of observed you doing what you're doing? And they seemed fine with it. And indeed, this is exactly what happened. They would bring out a stack of 240 checks and have the borrower start signing. And when the borrowers got tired, they would bring them chai and biscuits and they would proceed. Once they even brought them lunch, I thought was quite nice. But unusual, but nice. So they proceeded to do this. Then what would happen is every month the bank would deposit the check. And if for whatever reason you didn't have sufficient funds in the account or you removed the funds, that would be a bounce check. The bank would then, after discussing it with you, if you didn't pay, they would typically go and file a criminal case, FIR, First Information Report, with the police and start a criminal case. Now, I've spent enough time doing legal work on India to know that even a criminal conviction will take 4 to 8 years to actually eventuate. So, and the chance of a criminal conviction is actually pretty low in India, especially for something like this. But nonetheless, banks were issuing these bounce check FIRs at an incredible rate, actually. So I kept wondering, why would this actually work? Since most people, if they talk to an attorney, would say, don't worry, you're not going to actually end up in jail. There's very little chance of that. So I sort of started asking, why would you care? And most people said the same thing. In fact, all of them said the same thing, which was the process of going through the criminal justice system in India was the penalty itself. Now, I thought, and you might find that, to be very plausible. Initially, I thought it was the inconvenience of going to court, the potential stigma of being called a criminal, etc. No. No one was concerned about that. They were concerned about dealing with the police. This struck me as very strange. And I said, why would you need to deal with the police? This is a non-violent matter. What do the police have to do with this? Well, the problem is this. The way you discover that the bank has filed an FIR against you is you receive a summons. And in those days, and even until very recently, the way you got a summons was a police officer came and delivered the summons to you by hand. Now, as they all described to me in very elegant terms, the way it worked was a police officer would trek across, let's say, Mumbai, to come and hand deliver you this summons. And let me see if I get the phrasing correct. Police in India consider their time to be highly valuable. So if you've made them trek for 1.5 hours from one side of Mumbai to the other to deliver the summons to you, they would expect the borrower to recognize the incredible effort they've gone through in a non-air-conditioned car in the traditional way, which would be, of course, to give the police officer some money. Now, this struck me as strange because giving the police officer money didn't actually get rid of the case, because you would still actually have to address the case. All it did was it remove the police officer from wherever you were. So if you were at work, the police officer would stay there until they got paid. If you were at home, they would stay there and walk around where your neighbors are. As you can imagine what the implication is, they're trying to suggest that you've done something quite wrong. People would end up basically paying the police to go away. There was almost never any violence. It was just the inconvenience and the embarrassment of having the police officer stand there. Once you pay the police officer, what you would do is you would hire an attorney or go in person yourself to the court, seek a continuance. The court will give it because they're so delayed, they didn't want to waste time dealing with this kind of a case. And the net effect was another date for a trial would be set. Now, a new trial date is set. That means a new summons is generated. And that means another police officer becomes your best friend for one day. And that would mean you need to pay another round of money to the police to go away. But this struck me as very strange. But in functional terms, what's happening is you're paying a metered sanction for the delay you have in resolving your mortgage, right? Now, you might say, well, how can the bank resolve the mortgage? Section 138 is something called a compoundable offense, which means the complainant, the bank, can actually get rid of it whenever they want. So when you renegotiate with the bank to pay, they compound the offense and it disappears. No more visits from the cops. So it's literally a metered sanction, depending on how long it takes you to figure out that you need to renegotiate with the bank. The banks thought this to be much better than dealing with land mafias and goons, because the land mafias and the gundas would often increase their price once they discovered the value of the property at stake. And that led the banks to be in kind of an awkward position. And they also sometimes just didn't like dealing with the goons and the gundas. For those of you who are interested, I got a chance to actually explore how they priced out their services, which should frankly be a movie on its own. But nonetheless, it was something. Initially, I thought this must be a fringe thing. But the banks told me they were filing 10 to 50,000 bounce check claims a year. If that was true, I said there has to be data on it, right? Now, finding data in the Indian court system is usually a fool's errand. But I went and I looked, and incredibly, Indian courts, the high courts in India, which are like the intermediate levels of appeals courts, all have 3 divisions: civil, criminal, and God bless them, bounce check. It turns out that Section 138 represents 13 to 16% of litigation in the Indian courts, depending on what year you look at. That's around 5 million cases out of 30 million. That's stunning. I studied law for a while. I won't give you my age because that'll embarrass me. But essentially, I've never seen a single provision have that much litigation associated with it anywhere in the world. Now, were these 5 million cases all mortgages? No, they weren't actually. It turns out the knowledge of how to use the bank check regime, the bounce check regime, essentially moved across all installment payment structures in India. If you wanted to buy a car on a 2-year installment basis, you would sign post-dated checks for the 2 years of all monthly payments. If you wanted to buy a refrigerator, the same thing. Every structure of installment payments had exactly the same bounce check regime. That's what those 5 million cases were. That became the de facto debt collection system in India. At this point, I realized I'd kind of fallen down the rabbit hole. I probably should have realized that earlier, but you were sort of in the heat of the moment, so you didn't quite realize. This became implicitly the debt collection system. But at what cost? You've generated 5 million cases, none of which are going to result in a conviction. That's going to clog up the judicial system like crazy, which is exactly what happened. Okay, so am I going to end with a dark tale? Not exactly. What happens later? So why did I end at 2003? The reason is that it turns out in 2003, a new law came into effect called SARFACI. Horrible acronym, but basically it's a law about securitization and secured credit. What led to it? It turns out the banks that were in the system lobbied for it. Like, well, why are you lobbying for a change? Filing criminal cases is the cheapest way to enforce your claim in India because you don't pay anything. The government brings the enforcement action. The borrower pays the cop. You're doing nothing, right? Well, here's the problem. The banks had so much business in the mortgage sector, they tried to hire more attorneys to help them file more FIRs. And incredibly, they could not find more corporate attorneys in India. This struck me as incredible. How could, in India, you can't find more people? No, what happened was corporate attorneys were in very thin supply in the early 1990s. It turns out there were less than 2,000 corporate attorneys in all of India in 1993. There are 2,000 corporate attorneys in a 3-block radius in Manhattan. The scale is just incredible. And so they didn't simply have enough people to deal with this. They needed to find an alternative to doing this sort of one-by-one system of filing of bounce check claims. They also found that the court delays meant that they couldn't get their other business in front of the courts actually resolved because their own cases were backing them up on other matters. And of course, this is a difficult model to scale. Moreover, and this was one of the weirdest sets of conversations to have amongst a generally unusual set of conversations, that apparently after about 5 years, the police realized that they were being used as collection agents. And they said, you would show up with 10,000 bounce check claims. And the police would look at that and say, well, I'm kind of busy today. How soon do you need this? Which I took it meant that if you want it done in your lifetime, you need to pay me something to do it. And the banks began saying that, well, the trouble was the police, like good middlemen, took a cut from both sides. They extorted the borrowers and they wanted bribes from the banks to proceed with the law. This both made the banks get a little worried that this looked like corruption now because they're paying them to do something, but also it squeezed their profit margins because the police would figure out, roughly speaking, what the profit margin was and then try to extract as much of it as possible. They received complaints from the various courts. The Mumbai High Court actually told numbers of banks, we are not your collection agents. Stop bringing these cases. And so they decided they were going to push for some alternative. Right? Okay. What did they push for? So they had seen in the early 1990s that the debt recovery tribunal system had fallen apart, and they did their own diagnostics of why it failed. And their result was basically, A, there were constitutional issues, which are there. But second, and perhaps more important, they felt that the process of debt recovery was designed to reduce the amount of time you were in court by actually getting rid of procedures, which meant it also had to get rid of the tasks that lawyers did, thereby reducing what the amount of work lawyers had. Of course, as a result, lawyers objected to that, and you had various problems. This time, they came up with a different solution. Instead of trying to shorten the process, they simply reversed the burdens. They said, let us go and get a law that says, if you have a security interest, which is what a mortgage is, and you can show you have that, then absence of payment will lead the courts to give you control of the property immediately. And the borrower can then litigate in the Indian court system to overturn that. And if they succeed, you have to pay them whatever the judgment amount is. Now you're like, well, how does that change anything? It changes everything because now the bank doesn't have to wait to get the property. You as the borrower are now living in a property that the bank is controlling. Most likely they will ask you to leave. And so all of a sudden, the borrower now had to bear the burden of delay, and immediately that moved the borrower to try to resolve the dispute as quickly as possible. This pushed the banks away from doing the criminal stuff because they didn't need to. They could rely on this, which was not exactly what would be considered the most efficient system, but one that was acceptable to the players in the market, and it pushed them to go in this direction. You also then had sort of associated developments along credit rating agencies and so forth that made it easier to go down this path. All of a sudden now, in a span of a decade, we went from 0 bounce check cases to 5 million bounce check cases to Sarface in 10 years. I don't think I've seen market development occur that fast anywhere. And that's against 100 and some years of 0, which is incredible when you think about it. That, to me, itself is an amazing story. But what kinds of insights beyond that can one divine from this? To me, as a conceptual matter, the most interesting is the fact that development is occurring in multiple stages, right? The development of the market is not the law comes first or growth comes first. It's kind of a mix of everything. Essentially, what it looks like to me is some kind of improvisation followed by maybe some institutional change. And indeed, when you look at accounts of market development across other emerging markets, and even in the United States, you see something similar. Improvisation, if there's proof of concept, then you see people investing in institutional development. And I actually think that's a better way to think about it, because developing institutions is expensive and time-consuming. There's no reason for people to actually do it unless they think it will generate a return. That's where you need the proof of concept. The improvisation is your attempt to do the proof of concept, what some people would call muddling through. And that is important because there's so much uncertainty in market development. Now, a lot of people think, well, what if you protect property rights, people will develop. People don't believe you're going to protect property rights because for a very long time they've seen you haven't. Promises are cheap. Results talk a lot more, right? As a lawyer who focuses on enforcement, I can assure you no one cares what you're saying. They care what you can deliver. And as a result, if you're in an environment where there's been a lot of attempts to do stuff, but they failed, your credibility is at a low. You need to find a way to convince people that you've got proof of concept. That's what you've got going on here. And indeed, there's actually a fair amount of economic work suggesting that uncertainty on reforms tends to retard development. You need to find a way to convince people. And that, I think, is maybe a useful way of thinking about what's happening. Uncertainty is basically people learning about whether this market can develop with the tools you have. It's an information revelation function occurring over time. And as you get there, the number of steps involved will depend on the information, will depend on how quickly the uncertainty is resolved, and things of that matter. In some respects, it actually bears some interesting comparisons to the startup sector, which also has a feel of improvisation followed by institutional development and so forth and so on. And indeed, maybe one of the most fascinating things is even if the market develops, it may develop with institutions that don't look like what you'd expect to be there. And that's okay, because the institutions develop to fit the particular situation. Once you get growth, you might think about another round of institutional development, which suggests that institutional development is a stage process. You have Law Reform 1.0, Law Reform 2.0, Law Reform 3.0. Now, I say that both as a scholar, but also as a lawyer. Every time I've seen any kind of growth occur, it is typically in this process. We have a first round, a second round, a third round. How far apart they are depends on how much uncertainty is involved and how quickly the market grows. A few other things. I know I'm probably running short of time. So notice the key players here. In-house counsel or general counsel at banks. The role of lawyers in kind of designing a system that works. So there's a line of legal reasoning that suggests that corporate lawyers in particular, transactional lawyers, are really transactions cost engineers. They find ways to reduce the cost of engaging in transactions, mortgage being one of them, right? Now, what's interesting about this is not the typical kind of lawyering. Lawyering is often like writing a clever contract, or maybe you create a social norm. They're relying on the predictable extortionary behavior of the police. That is not a standard story of how lawyers engage in market development. They're taking advantage of what they anticipate will be the expected behavior. They were correct. Indeed, they were so correct that they actually could tell me in advance what the sort of extortion market would look like. That is, the cops, if they understood where your property was located and its net worth, they would show up at your work. If they didn't understand the value of your property, they'd show up at your home because they needed to understand the value of your property before they could figure out what would be the extortion amount they would take from you. This is a pretty refined market as these things go. A little bent, I agree, but let's not be pejorative this early. It is what it is. It's also not typical private ordering, which people sort of think of as being amongst communities, right? Diamond merchants and the Ashkenazi Jews, or Jannies in the diamond markets or whatever. But it's still a norm. Extortion is an anticipated norm, but it's not from a small group per se. It's sort of a general understanding of how the market works. And that sort of raises all sorts of fascinating theoretical questions, which I won't have time to go into, including, well, what is the value of extortion by the police versus extortion by organized crime, such as the gundas and so forth? That all are sort of interesting questions on private ordering. It also has kind of weird affects on corruption and development. If you treat extortion as being a form of corruption, this sort of suggested that extortion helped to grow the market, but then it cannibalized the market, leading to law reform change. And when you start looking at growth in other markets, you actually notice this often at early stages of growth, this sort of what we might call corruption or law breaking, or what some people call the Uber model of business, right? Involves a little bit of playing fast and loose with the rules. But if you want to scale, you can't make a market like that. To do that, you need to actually have a structure and a law or at least some understanding of how it's done. So again, this is another sort of argument of multi-stage development. Early on, you have sort of muddling around, and then you have the metastasization towards a broader conception of what's going to happen. This also connects to the institutional voids literature by a different Khanna, Tarun Khanna actually, who sort of suggested that often the value of emerging markets growth is in the institutional voids. When they grow in those areas, they're able to construct institutions then that help them scale in larger ways. And finally, of course, it wasn't just the Indian banks that lobbied for SARFAESI. Around the same time as 2003, the government of India actually opened up more to allowing foreign banks to come into India. When they saw this market, their reaction was, we don't want to get involved in paying bribes to the cops at this point. We would like to have a more structured system. They also joined in the lobbying for SARFAESI. To underscore one thing about SARFAESI, it was pitched as a securitization law. It did very little to grow the securitization market in its first decade. Another part of it related to secured financing, and the major form of secured financing in India at that time was bank-provided loans for mortgages. That was code. That was what they had lobbied for. They wanted it to be invisible to the naked eye, but they didn't want to short-circuit the legal process, just reverse the burden. There are many other potential implications one can take from this and many other kinds of ways you could think about market development. But what I would say is I don't think this is unique to the Indian idea. The particular example might be, but the way in which the market has developed, that I think you see in a lot of sectors. Indeed, every now and then when I get tired of doing white-collar crime, because, when you look at the dark underbelly of business, you can get a little bit of a dim view of the world. So I'll often actually teach a course on startups because that seems effervescent and exciting. And the only trouble is every time I teach that, I get venture capitalists and entrepreneurs to come into my class, and the main thing they say is fake it till you make it. And the trouble is, to a white-collar crime attorney, fake it till you make it sounds like fraud. Because it is. And so as a result, I've come to the conclusion that there's a certain amount of muddling through in different degrees, some legal, some not legal, that seems important at the beginning until people resolve enough uncertainty that they're going to invest in institutional development and compliance with that. If we have time, I'd be delighted to give you some other sort of anecdotes about examples I've seen in India where people actually wait to see proof of concept before they change their behavior. Equilibriums exist for a reason. Changing equilibrium requires you to convince people that things will not revert to the status quo ante. That is a very hard thing to convince people about if they haven't seen it before. With that, I'll end, and thank you again for your time, and head over the total curriculum.
Thank you, Professor, for that fascinating story. We will finish by 11:30. Let me call upon Professor Shruti Rangarajan for her remarks.
Thanks. So thank you so much, Ajay, and everyone involved in putting this together. It's a really fantastic program. Thank you, Amit, for putting this together. When I was told that I have to be a discussant on housing mortgage market, you can imagine my first reaction. But I knew Vikram is doing this, and I've been following his work for a long time, so I knew it would be something really, really fun, and he didn't let us down. I first thought that the way he would go is make this a very geeky sort of law and economics paper. You have property rules, you have liability rules. This is a fantastic case where we switch from one kind of rule to another kind of rule, and that's where we end. But actually what he's ended up doing is what development economists should be doing, right? I hate to disagree with the ambassador and Mr. Bukundan, but we don't grow by setting targets, right? This is what economic growth looks like. Right? People just truck, barter, and trade, as Adam Smith put it. That's how the size of the pie grows. And this is, at the core of it, a fantastic development story. So now that Vikram's put me in a very difficult place where I don't have much to critique in his paper or disagree with him, I thought I would make his life equally hard by adding on some things so that he has to either write another paper or revise this paper. So most of the comments are in that vein. So the first question you raised, Vikram, is why did the housing mortgage market not grow for so long, right? And you gave us a number of reasons. I mean, the Transfer of Property Act and the way we deal with mortgages. I don't disagree with any of that. But I will add that we started seeing urbanization and a service sector emerging sort of from the early 70s, right? You can see this in the aggregate data. India starts slowly moving. So now, instead of the 100-year period, why didn't we see the uptick in that last 20-year period, right? And here, it's just directly because of, command and control under license permit Raj. So for those of you who were in India at that time, basically we controlled everything. But there are many things that it takes to build a house, not just credit. Credit is usually the last step. We controlled cement until 1982. And for the young people in the room, when we say we controlled cement, we mean we told cement manufacturers how much they can produce and what price they can sell at and how much profit they can make. And those once, that causes massive shortages and black market emerged, then we started issuing permits to people who were building houses, right? My parents have a wonderful story, and this was not just for cement, though cement and steel were sort of the worst offenders, and steel was an essential commodity. My parents were building a simple one-story home in the late 70s, and their criminal activity was buying paint from the local mafia or bootlegger of paint, because paint was a substance in shortage. Again, not part of the Essential Commodities Act, but when you control everything, then you are not yet worried about how will I get a loan for a house that doesn't exist, because there is no cement to build the house to exist in the first place, right? So the last 20 years is really that story. And I think, it's also maybe not as colorful as this story, but it's quite colorful. Another reason is people were sort of borrowing money to build homes, but it was family and friends and local money lenders. And there is there's a reason we don't have contract enforcement in India, right? Because we've demonized the money lenders. In fact, we've criminalized we have usury laws in virtually every single state, some of it going back to colonial times, some of it still exists today. So when you criminalize one party, it's sort of ought to expect courts to then enforce a contract made by that particular party, which is the claim that, borrower has defaulted. So what I'm trying to get at is there's a cluster of constraints, and this is a very classic emerging economy or developing country problem, right? And when there's a cluster of constraints, is it steel? Is it credit? Is it paint? Is it the usury laws? Is it lack of employment? Is it lack of urbanization? You don't know which one is the binding constraint, right? So in 1982, you decontrolled cement. Okay, now you can breathe a little bit easy, but you still have a whole bunch of problems. 1991, you decontrol almost everything, right? And then credit becomes the binding constraint. And that's when this story really starts, right? It's no surprise the National Housing Bank comes in 1990. There's an order in which these things happen because we managed to get rid of the cluster of constraints one at a time. Now, the second part of the second question you raised is, why was Section 138 of the Negotiable Instruments Act so useful, right? And the simple answer is contract enforcement is not a priority in a socialist system where you think anyone selling anything is fundamentally exploitative, right? So contract enforcement is simply not on the cards for anyone, including the judges. So one problem is a mindset problem, but we are sophisticated lawyers and economists, so we won't talk about mindset and vibes and things like that. We can point to more specific institutions. But the interesting thing about Section 138 it goes from what is called a liability rule, turns into a property rule, and then goes back to a liability rule. So for those who are not law and economics nerds like Vikram and myself, a very simple example of this is if you have a car parked in your driveway, right, and someone comes and vandalizes your car, that's not allowed. Even if they make you whole later, the act of vandalism is considered trespass, it's a criminal activity, shouldn't have happened in the first place. That's what we call a property rule, right? On the other hand, if someone dents your car when you're driving it on the street, we don't say that shouldn't have happened in the first place, you need permission, like we do in the case of trespass. We just say you have to make the other person whole, which is a liability rule. Now, when you hear this example, it intuitively makes sense, right? Sure, you should request permission before you enter someone's driveway and dent their car by mistake or vandalize it by mistake. On the other hand, when you're driving on the street, it's impossible to get permission from everyone. So what do? You ask for forgiveness, you make them whole. So this difference between property and liability rules, at the core of it is a difference in transactions costs, right? it is very high transactions cost to go to every single person on the street and ask them for permission for whether you can drive next to them. God forbid you dent their car, right? You can do that for a single car parked in someone's driveway, which is on their own property, and you know that this is someone else's property. Now, this rule is very similar, and law and economic scholars have theorized about this for a long time. So, there's a famous paper by, Calabresi, Melamed, which outlines the system. And then there are a number of law and economic scholars who basically say property and liability rules can be used interchangeably, except you would normally see liability rules being used in a system where there are very high transactions costs, right? So actually, the paper that you've written, Vikram, is much more sophisticated than you let on. This is a fantastic case of when it's relatively low transactions costs, you rely on the property rule. As transactions costs keep increasing, which is, the process is punishment first for one side, which is the borrower, then the process starts becoming punishment for the lender side. And you say, okay, now this is very high transactions costs. We need to find a way around it. So you switch back to a system which is one of liability rule instead of property rule with the criminal sanction. So I think some discussion of this would be, this should be another paper, since we are imposing costs on each other, right? The other part, and even here the mindset does come in, is there is a David and Goliath problem here, right? I mean, the same socialist judges who are enforcing these rules, who refuse to enforce contracts and default payments to start with, they're going to pick up pretty quickly that, all the check bouncing cases are being filed by really large banks, right? And debt collection agencies and things like that. So I think this had a short run to start with. I'm kind of amazed they got away with it for 10 years by imposing the cost. And Vikram pointed out that it's 13 to 16% of the high court cases. It's an even larger proportion in the district court, which is the lowest court. So these are cases where the ticket value is large enough that it's actually gone up to the high court eventually, right? So it's really clogging up the system. So as a system, I'm pretty happy we got away from it. Now, the last part of the paper talks about how did we actually make the transition, which is another very interesting developing country story. And here, I think the big takeaway is that none of the banks simply lobbied for themselves, right, to get some special enforcement or something like that. They actually lobbied for the system, right, which is quite interesting. Now, lobbying for themselves would look quite simple, like, you could have specific tribunals, right? You could have particular judges who you buy out in some shape or form, either legally or illegally. But what they did instead was get the law changed. And now, how did that happen, right? And I think here, Vikram, you had a sentence in the paper that says maybe two wrongs make a right. There's a third wrong in there somewhere, which is the National Housing Bank is this really curious animal, I want to say, right? Because the National Housing Bank was supposed to be the lender to housing finance companies and banks. So HDFC and, if you have Divan Housing or something like that, they are loaned money by National Housing Bank, which is a fully owned subsidiary of the Reserve Bank of India. Except the original National Housing Bank Act made them the lender for housing finance companies, but also their regulator, right? So imagine if your lender is also the regulator who decides if you can operate in the industry. National Housing Bank, if you read their reports, famously had near perfect collection rates, right? Pretty much all the money they lent out came back, which is extraordinary because they were regulators. Now, this got amended in 2019, right? So from 1990 to 2019, National Housing Bank is also your regulator, but it has two sides to that coin. So one is the housing finance companies are now getting squeezed, or the banks are getting squeezed on both ends. Your regulator and your refinance guy is going to say, I want 100% of my money, but you're going to be stuck in this very complicated check bouncing system somewhere else. And note, National Housing Bank is a fully owned subsidiary of the RBI, which means its board is full of like RBI officials and IAS officers and so on and so forth, right? So at some point, this lobbying for SARFAESI becomes really straightforward in a way that may not have happened in another circumstance if National Housing Bank had just simply been their lender or simply been their regulator. So this is many, many, many wrongs which have ended up putting us in a surprisingly good position. But this is really my favorite kind of development paper, not the RCTs and not the other stuff we do. This really shows how a market grows and how people actually start getting rich and start getting access to credit and start getting housing and so on and so forth. So congratulations on the paper, Vikram, and this was a joy to read.
Thank you, Shruti. We're open for questions. We have about 5 minutes before we move on to the next session.
Oh boy.
Yes, sir.
Congratulate this listening for an issue of law for the first time. So for this, I think it's a welcome change. I made the comment the last year that the process of fixing the law in India is one of India's biggest development challenges. So I'm glad you got that there. I have a small cavil to pick with Professor Khanna, which is your story that it took the Bombay policeman 10 years to figure out he could get paid by the lender is simply not credible. Now, I hope the 16th guy who died before you met, it was not a kind of Vance meeting the Pope kind of deal, right? But I do wish you would go research that part, because that I find was the weakest part of your story, that these 60 GCs said, we never bribed anyone. Those guys paid the money and the policeman. So, okay, that's a weak part of the narrative. Now, the interesting part of the mortgage question that you say, and here, Kurt Vonnegut accused Thomas Jefferson of being a theoretician on the subject of liberty, because of course he had slaves. Is it possible that the present panel are theoreticians on the subject of justice? I'd like to hear if any of you have been in a real Indian court, faced some of these issues. The narrative is droll, and I think humor is a great way to help effect change. But is it at all real? Are these the real issues of the Indian market that actually should give us insight or give us a pathway to change? So it's a kind of a broad remit. It's a little bit of a hostile criticism. I apologize for that. But I'd like to be able to hear some bigger picture answers for the prospect for change in India. And for the rest of the crowd who haven't watched it, Netflix has a great series called Mamla Legal Hai about the district court of Patparganj. It's a much more authentic view of what the Indian justice system is. And I give it away to anyone else who may have.
Vikram, let's take one more question and then we can go. Yes, sir.
Fascinating paper. I wish I'd read it. I started my career in development on development of housing finance in East Asia. And I wish I'd read this paper at that time. We would have been more successful at the World Bank. But I think what you've done is fascinating, and I would be more interested to learn a little bit about implication on the two sides. One, downstream. What are the implications for secondary market, mortgage market development? Secondly, for the transformation of the cash-based economy. Because you see now in India that the cash-based economy, which is sort of pervades the real estate sector in small towns, is reducing in the bigger metropolitan centers. And I wonder if this is the other side of it is on the, one of your colleagues, I think it was Michigan, has done a similar sort of paper for China on development of e-commerce law and how, I mean, it's in the same genre, but I was wondering if, since you've looked at startups, because, and how e-commerce law changed in China, and what implications we have for India, because we are struggling with some of the same issues in the legal system for e-commerce in India. If you have any thoughts on that. Thank you.
And thank you all for your comments, which I agree with. So in response to your question, so Greece didn't take 10 years, they took 5. And the reason was that at the beginning, the banks were not filing thousands of cases straight off. They started with a few hundred, essentially. And then as they saw it was working, there you go. I'll speak about rare that someone asked a lawyer to speak about it. So I'll do that. Essentially, they started with hundreds and they got to the tens of thousands by year 3, approximately. And by year 5, the cops started coming to them and saying, hey, you need to essentially give us money to go faster. That's why by the 10th year, they had already figured out they needed a different strategy and were lobbying to get that to happen. So our base income was at the back end of that 10-year window with about a 3-year lobbying window before that. On your broader point about our needs issues, so it's very hard. I've been in Indian courts a fair amount, and at one point my family had appointed me to run a series of trusts they had to manage the property in India. So I have a lot of experience dealing with property management issues in India. Indeed, I think almost all the gray hairs on my head are from there. And the hair I'm missing is also from there. But the gist of it is that most of the issues, at least on the property side, are related to steps in the process. And the more you go into the process to try to handle the matter, it just sucks you in. You need a way out to get a quick result. If I was advising someone in India who had a dispute over property or contracts, what's the best way to get an outcome soon? I would say hire a high-priced attorney and look for an interim order, because that will reverse the burden of delay on the other side, and then you can kind of relax it. So that is hard for a lot of average people to do, to find someone who's got that kind of cadence with the court, that they can get an interim order with no facts in front of them. But that's, if you're asking for like what is the quickest path, that would be the quickest path, most likely. Are these similar issues of development, depending on the sector? Yes, depending on what the issue is. If you're worried about human rights, this is not going to be directly related, for sure. A gentleman's question here. I'm aware of my colleague in the political science department. Her name is Yunyan An, and she's written about market development in China, looking at e-commerce and other sectors too. There's another paper on the development of Nigeria's Nolly, their movie market, or their cinema market. And there are similar attributes. The main ones being that there's a period of sort of searching around for ways to make the market work using existing institutional tools, because you don't have the lobbying or the political support to change those tools, right? Remember, if you're a startup industry, your lobbying power is essentially zero because you're not there yet. Once you've got proof of concept, then you've got people interested. You can begin to get tools, but then you have to make a strategic choice. Do I want the tool that's the most efficient, but will take a decade to get? Or do I want the tool that will be fit for purpose, but maybe not perfect, and use that in the interim? And I think that's the kind of model both Yunyan and I have sort of found works pretty well. My paper here goes more to the conceptual side of multi-state development. First doesn't do as much of that, but that's because she's more interested in case studies.
I think that's probably all the time we have questions for. So I'll just close very quickly. There was a question about, do any of you have practical experience with the courts? Actually, there are several of us in the room who have been in the Indian civil service, and we've actually held court. But
I'm a lawyer.
very quickly,
still enrolled with the Bar
Third
Council
law.
of India.
But I think this also highlights the role of informal and formal systems and networks. And the fact, as Shruti said, a lot of this action took place at the district level and in metros and tier 1 cities. We still have in India what's called a state level bankers committee and a district level bankers committee, which as district magistrates, we spent a lot of time on. And what typically happened, I was reflecting on this, if the bankers said, look, we need help to deal with this, all that would happen is that I, as a district magistrate, would request my superintendent of police to make this a priority. And the public prosecutors were reporting to us, so we had that channel open too. And we had very close working relationships with the district judge and the judges there. So there was an ecosystem which worked both in the formal sense and, more importantly, I think in the informal sense, personal relationships. And the lesson I take away from this is that when a nation state or a state or key actors of a state, and bankers are part of that, want a desired outcome in the public interest generally, it usually finds a way to make that happen. And modern times, current times, if you look around the world, they're no exception to that. Let's finish here. Thank you.